This is Barry Zalma speaking for Zalma on Insurance, a blog. Today I'd like to speak about the problems that arise when an insurer sues another insurer only to find it has wasted its time. To prove a right to equitable subrogation or unjust enrichment requires actual evidence of a right to subrogation or that someone was equitably and unjustly enriched. Two insurers of Gateway Science and Engineering, Admiral and ACE American, settled a suit against Gateway, and then Admiral sued ACE American to recover its share of the settlement. Admiral Insurance Company appealed the district court's decision granting ACE American Insurance Company's motion for summary judgment. In Admiral Insurance Company, a corporation versus ACE American Insurance Company, the Ninth Circuit Court of Appeal on July 5, 2022, resolved the dispute. Gateway's work as the manager for a construction project in Los Angeles was protected by insurance coverage under Admiral's professional liability policy, which covered claims resulting from negligence in Gateway's provision of professional services. Gateway also, to protect itself, obtained coverage under AAIC's Commercial General Liability Policy, which generally covered claims resulting from bodily injury or property damage. The Admiral Policy excluded claims covered by a Commercial General Liability Policy, and the AAIC Policy excluded claims arising from Gateway's rendering of or failure to render any professional services. By their terms, the policies did not overlap, but insured against different risks of loss. Hartford Fire Insurance Company sued Gateway, alleging that Gateway's negligence had damaged a construction project. AAIC and Hartford agreed to settle all claims against Gateway covered by the AAIC policy. A month later, Admiral and Hartford agreed to settle the remainder of Hartford's claims against Gateway. The appeal that resulted from the trial court's decision occurred because Admiral sued AAIC, alleging that as part of its settlement with Hartford, Admiral had paid Hartford to settle claims for which AAIC was responsible. Admiral appealed the federal district court's decision to grant AAIC's motion for summary judgment as to 6 of the claims presented by Admiral, which included 1. Breach of the implied duty to settle, 2. Breach of the contractual duty to indemnify, 3. Breach of the implied duty to indemnify, 4. Equitable indemnity, 5. Equitable subrogation, and 6. Unjust enrichment. Although an insurer has a duty to settle once liability of the insureds becomes reasonably clear, an insurer has no obligation to pay money in settlement of a non-covered claim. By settling all claims covered by the AAIC policy, AAIC satisfied its duty to settle. Although an insurer has a duty to indemnify the insured for those sums that the insured legally becomes obligated to pay as damages for a covered claim, that duty arises only after liability is established. Because all claims against Gateway were settled before liability was established, the duty to indemnify never arose. The Ninth Circuit, therefore, concluded that Admiral cannot recover under the doctrines of equitable indemnity or equitable subrogation. Equitable indemnity applies only where two insurers were obligated to indemnify or defend the same loss or claim. Since the AAIC policy and the Admiral policy did not overlap with each other, AAIC and Admiral were not obligated to indemnify the same claims, and as a result, Admiral's claim for equitable indemnity failed. In turn, equitable subrogation applies only where one party pays a debt for which another is primarily liable. By settling all claims covered by the AAIC policy, AAIC erased any debt it owed to Hartford or to Gateway. With that debt erased, Admiral's settlement with Hartford could not have paid a debt for which AAIC was primarily liable. The Ninth Circuit also concluded that Admiral's claim, therefore, for equitable subrogation failed. For similar reasons, Admiral's claim for unjust enrichment failed because under California law, the elements for a claim of unjust enrichment are receipt of a benefit and unjust retention of the benefit at the expense of another. Because AAIC settled all claims covered by the AAIC policy, AAIC did not receive a benefit from Admiral's settlement with Hartford. Accordingly, Admiral's unjust enrichment claim also failed. In my opinion, equitable subrogation, equitable indemnity, and unjust enrichment claims require two insurers insuring the same risks of loss. Since the two insurers involved in this case insured different risks of loss, neither were entitled to anything from the other, and this should have been obvious to the two insurers and at least obvious to their counsel that they paid for different risks and different losses caused by the actions of their insured. This video was adapted from the blog post at Zalma on Insurance and is available free to anyone who wants to look on both YouTube and rumble.com. If you found this video useful, you might want to subscribe to the YouTube and the Rumble channels and to the blog. And you might also consider subscribing to my locals community, where I am posting a regular recitation of excellence in claims handling, which will go on for many, many weeks as we read from and proselytize about the Excellence in Claims Handling program adapted from my treatise Zalma on Insurance Claims. Thank you for your attention.